The chair lays out as pending business, House Bill 1086 and recognizes the author, Speaker Pro Tem Joe Moody, to explain the bill.
It's 10:15 and you only have 5 bills to go? You got a long, I was gonna say, this is an easy night for the Criminal Jurisprudence Committee, in my estimation. So I'll do my long version of my layout. Is it? No, Mr. Cook, it's Mr. Cook, right? You're David. So I'm on the calendars committee, so I'm going to remember all of what happened tonight. So thank you for your bill. I appreciate the time we spent on it. You got a couple of bills over there, right?
Yes, sir.
That's what I thought. Okay. It's okay to have fun. You gotta have fun. You gotta enjoy your time here. No, and I will say this. I know there were chuckles rippling when you said there were 5 bills left, but look, the bills that this committee considers are very literally life and death. And so while we chuckle with one another and we have long nights with one another, and this committee will continue to compete with every other committee in this building for the longest hearing you have every session. And you should take great pride in that, because that means you're deliberating on your bills. And this is the first session I haven't served on this committee, and maybe I just miss it, so I had to sit with you. So I bring this bill to you tonight, Madam Chair, members. House Bill 1086 is a direct result of the work this committee did during the interim leading into the 86th legislative session. We worked on state jails and state jail felonies at that time. The information we received is laid out in detail in the committee's interim report, which the chair will tell you is always a labor of love. And I encourage you to review these. It sits on a shelf somewhere, I'm sure. It's at least on my shelf. What I'll tell you is that the state jail felony level of offense was created back in 1993 as a method of diversion and treatment designed to get offenders back on track and save the state money while doing it. These were supposed to come with all kinds of programs and incentives for that very purpose. But what we've done in the decades since then is failed to ever create a meaningful programming. And the incentives we created actually push people to simply take a jail sentence and sit out their time. These are certainly not the kind of people we need to be locking up. Nearly 90% of the offenders in our state jails are there for low-level drug or property crimes, and both the recidivism rate and the cost of incarceration are the highest of any category of offense. If you want me to save you the trouble of reading the interim report I mentioned a little bit earlier, here's how it ends. And I quote, "Bluntly but factually, Texas's state jail system is such a complete failure that it's come to literally produce the opposite of its intended result in every measurable way," end quote. HB 1086 does something we should have done a long time ago, which is eliminate state jails, both as a category of offense and a kind of facility that houses those offenders. The bill would allow TDCJ to repurpose existing state jail facilities for any other appropriate use and turns many state jail felonies into a new category, the 4th-degree felony. It would have the same range of punishment as state jails do now, except that offenders would be housed in regular prison facilities and be eligible for parole, unlike state jail sentences are currently. The biggest change, though, is that 2 kinds of crimes that account for almost all jail sentences, state jail sentences, which are possession of less than a gram of a controlled substance and minor property crimes like petty theft with 2 prior convictions, would be reduced to a Class A misdemeanor. That would incentivize these offenders to get into diversion programs, to get on probation with all its services, to take part in specialty courts that can help them break the cycles of addiction, poverty, and other issues that help lead them into the criminal justice system in the first place. I'd like to direct your attention to the fiscal note, which shows a savings of $130 million every single year to the state of Texas. Beyond that, though, this bill will save our local governments a tremendous amount of money that I don't think it's easy to account for, but which will definitely be felt in your districts. Currently, a huge portion of these sentences are being served in our county jails. With existing incentives promoting short jail stints, people are choosing that, and many serve all or most of their time in the county before ever finalizing a state jail sentence. By reducing some penalties, we'll actually get these people out of our overcrowded local jails. Most of all, though, we'll make Texas safer, fairer, and more productive, which is all we can ask for any smart on crime policy. With that, I'm happy to answer any questions, and if there aren't any questions, I'd ask for the chair's permission to be able to close after any testimony.
Absolutely. Representative Crockett?
Mayor Pro Tem, it's way too late.
Sure, that comes with a paycheck, actually. I'll take it.
Nah.
It would be Speaker Pro Tem. There we go. So I absolutely am in love with this bill for a million different reasons. My only question is currently we've heard about 3 strikes, and in our world, what that means is if you have a TDCJ felony, that can be used for enhancement purposes. And obviously, when we deal with state jails right now, it takes 2 state jails and then you can be enhanced to a 3rd degree. If we end up doing a 4th degree, would we now be saying the 4th degrees would be classified like 1st through 3rd and could be used so that if you end up with 2 4th degrees?
As a pen trip.
Okay.
Like using it as a pen trip to habitualize? Is that what you're talking about? Let me look into because I know we've gone back, because this actually used to be the construct we had before state jails.
Okay.
Let me make sure that I have the right notes on it. I sat there longer than I thought I was going to sit there, but I'll get you the direct answer. I just want to
Okay.
make sure I don't misspeak, and I left my notes.
Okay, that was my only question.
No, and I got that question from a couple other folks as well.
Okay.
So I'll get you that information.
Representative Cook?
Thank you, Madam Chair. Just had a quick question because I don't do any criminal law, and so are we going to lose any, like, I guess, rehabilitative or counseling programs? I thought I've heard some of that just through this committee that a lot of the I guess good programs are part of the state jail felony punishment. Is that accurate?
Intended as such. Okay. Well, and really and truly, and since my time in the legislature, which is much longer than I'd like to admit right now, there was always a very noble concept here, which was connect folks with what we thought were lesser felonies to programs, to services. But the amount of time that someone actually spends in the state jail system is not significant enough to be able to plug into those programs. And so while they exist in some facilities over others, I'll tell you where they do exist. They exist in the probation systems, the community supervision systems back in our counties. And you'll have more time there too. What happens is people end up sitting a certain amount of time in the county jail, then they process them, then they go to the state jail. They're in and out of there. It's a revolving door. They don't ever get plugged in. And I'm not saying this is 100% true, but for the most part, you're not getting plugged into the programs that can most help you, right? And so, and I talked to the folks at TDCJ prior to coming up and presenting this bill, and the main thing I want to make sure that you know, this is not any disrespect for their programs. In fact, I think if we, as a legislature, gave them the funding and gave them what they actually needed for these programs and gave them the time to spend with these folks, it might actually work. The problem is, since 1993, we've never done that for them. So we gave them a tool without any way to function. And so we actually have these tools at the community supervision level of the county. So let's take these folks back home. It's where they're spending the bulk majority of their sentences anyway. We've perversely incentivized people to spend time in county jail instead of going to get these programs. And so, again, not trying to disparage what they do there. I think they could do something if we ever give them the opportunity to, but we never have. And so 30 years down the road, I just think it's time for us to.
But if there are any good tools in the toolbox, like I've heard of Safe P, seems like they've had good results.
Mm-hmm.
Does that come out of a state jail felony?
No, I mean I think the programs that exist are places you can send people to any of that stuff,
regardless,
whether you put them to state jail or not.
Thank you.
Yep. Yes, Representative Johnson.
Yes, Speaker Pro Tem Moody, and as you may want to articulate more for this committee.
Maybe.
Maybe not. Since the 90s, we also got into a wave where state jail was created. If you had less than a gram, you were obligated to go on probation. It was the purpose was to get you treatment. And then we got overcrowded, didn't want to spend the money, and created 1244A. And 1244A created a felony conviction with misdemeanor time, where we then push people out of the county jail, save the county money, some the state money, and now people are running around with a felony conviction.
Correct.
And
so
talk about the consequences.
And I appreciate the opportunity to expand on that, because I know this committee has a lot of time. And so I will start every conversation with the very simple question. What is the goal? And you've heard testimony here today on other bills that talked about services and getting people out, track them out, right? But the fact of the matter is most of these crimes are small possession, personal use possession drug cases where we're incentivizing people to take time and take a conviction and get out. And I've represented those folks. And you beg and you plead with them, and I know you've done the same thing. You beg and you plead with them. Don't do this. We can get you something better. You have a substance use issue. We can get you help. And you as a defense attorney are end up fighting against your own client because they see something that's lesser that gets them out of the system, they can go back. That doesn't end the cycle. You need to incentivize. If you want to incentivize something, incentivize the help. Right now, we're not incentivizing the help. And unfortunately, for too long, we take complicated issues like substance use, like poverty, and we say that's too complicated for us to figure out. And so we're just going to throw you in jail, county jail, state jail. We're going to incarcerate you, and that's how we're handling you now. We don't want to figure out how to handle your very complicated healthcare issue. We don't want to figure out what the societal issue related to poverty is. We're just going to put you in jail. That's easier for us. We can now create an other out of you. You're now someone that's not us, right? You're now justice involved, and we're not going to deal with you. And so ultimately, we need to stop that. It's not easy because for too long, we've treated these problems as criminal justice issues and not in their proper space. But to your point, we're not focused on the right question or the right result. If we're trying to get better outcomes for folks, what are mostly victimless crimes? And those that have victims, I think there are places to move them up into the 4th degree felony world. But truth be told, most of these things probably need to be in the misdemeanor world. So let's reclassify. We got it wrong. It's okay to admit that. And there's no blame to lay on anybody, but we can do better.
And I would also agree with Representative Crockett of not wanting the 4th degree felony to function as
Yeah, let me look at those notes, and on my closing, I'll come back and address that.
Thank you. Members, any other questions? All right, thank you. We'll call you back up to close. The chair calls David Bass. Major David Bass.
I'm David Bass, speaking for the bill, representing myself.
Okay.
And I'm real tired, so I'm going to use my phone if that's okay.
All right.
So I'll make sure I say this right. And thank you all for your hard work. So I'm an Army vet who uses cannabis as medicine for chronic pain and PTSD. I served in the Army for 25 years. And so I use the cannabis instead of pills. And so when I purchase cannabis, I purchase 1.5 ounces. So that's 1 ounce and that's a half. And that's a month's worth of medicine for me. Because I vaporize in my PAX vaporizer 0.5 gram of cannabis 3 times a day, instead of taking pills 3 times a day. And so that is currently a Class B misdemeanor. So that much cannabis is worth 6 months in jail for me. But I'm willing to take that risk because I'd rather do the jail time than the pills. And so just like it with any other medication, once you get down to a certain level, it's time to refill your prescription. So when I get down to 1 ounce, I go purchase another 1.5 ounces. And so now I possess 2.5 ounces. And that gets me into Class A misdemeanor territory. And so this extra 0.5 ounce is another 6 months in jail. So 2.5 ounces equals 1 year in jail. And so I'm just addressing a small part of Representative Moody's bill, the part that affects me. And so it seems to me more reasonable that up to 4 ounces, like in Representative Moody's bill, would just be a Class B misdemeanor, rather than drawing that line between 2 ounces and 2.1 ounces. So I hope I said all that logically. I hope in the future we can talk about just legalizing cannabis, but for now, that's what I wanted to talk about tonight, is this issue of up to 4 ounces being a Class B misdemeanor. That makes more sense to me.
And I think I heard the word allegedly. I mean, everything that you said, allegedly used and all that stuff, I think.
Hey, I talk about this.
I think that allegedly, it's,
I talk about this all the time. I've been testifying up here since I started using medical cannabis in 2012, and I started testifying in 2013. So this is my 5th session.
you make it out every time.
So, and I always testify in front of this committee and the health committee. So I appreciate all your work.
Absolutely. You really are here to advocate. You go to both committees.
Yes.
Yes.
For the medical, usually.
Obviously. There's a bill for that too. Representative Crockett?
I just wanted to make sure you're willing to come back, especially if there's a bill saying that this should just be a Class C and no jail time.
Yes, ma'am. Yes, Representative. We're watching all those bills and eager to return.
Okay, sounds good.
Members, any other questions for Major Bass? All right, thank you so much.
Thank you.
Great.
Thank you.
The chair calls Sable Thornton.
Hello, I'm Sable Thornton. I'm the social media director of Cannabis Reform of Houston. I'm testifying on behalf of them and myself. I'm for this bill, by the way. Just let me get my thoughts together. I do apologize. So I'm testifying on behalf of Bill 1086 because I believe that cannabis should not have the harsh penalties that it currently stands in today. I personally use cannabis as a means to treat mental illness and other chronic illnesses that I deal with that cause me a lot of pain and a lot of distress in my life, as others in my life also experience. There are little to no side effects that cause any kind of harm or any kind of violence or any kind of misbehavior or anything that come along with cannabis, as opposed to the pharmaceutical medications that I was on as a child. I've been on pretty much every antidepressant and antipsychotic you could name. I don't know the names of all of them because I was never told, but I do know I was on a lot of pills. From the age of 14, I think I was on 17 of them. So all of the pills and the way that they had me feeling, I just couldn't accept that. So when I got out of CPS and was allowed to make my own decisions about my medical use and how I choose to medicate my illnesses, I chose to stop taking pills and pharmaceuticals, and I chose to switch to a more natural remedy. And I chose to join Cannabis Reform of Houston to fight for the legalization of cannabis. But today I'm here to advocate for less harsh penalties, and I don't believe that anybody deserves to be locked in a cage for a plant. It's God's gift to us. Nature gave us this bountiful plant to help heal us and to help us live a happy, fulfilling, fruitful life, free of pain and heartache and other various ailments. We've seen it help kids with seizures, minimize their seizure activity. We've seen it help cure cancer patients, have helped cancer patients go into remission. We've seen it help glaucoma patients. Sorry. And we've seen it help my friend. She has trigeminal neuralgia. There's many different disorders that I could name, a myriad, a list of them that I could name that cannabis has a use for. It does stand that it does have medical use currently in the definition right now. We know that in our bodies we have an endocannabinoid system in which cannabinoids naturally are placed within our body and reside there. So that is a natural system that we have in our body from the day that we're born. It's just a part of us. So, you know, there's always, you know, medical science to back up the fact that there is medical use and help, that it's not dangerous and that it is less harmful than even alcohol and cigarettes, which arguably have a similar addiction rate. Anything like that that you could think of that might be addictive. Addictive personality is really the lead cause behind that. So there's no physical addiction that comes with cannabis. You can't really come from any kind of withdrawals from it. So that's why I choose to use natural remedies instead of pharmaceuticals, because coming off and the side effects are not nearly as bad and as detrimental to my health as the pharmaceuticals were.
Members, are there any questions for Ms. Thornton? Thank you for your testimony and for being here today. We appreciate you.
Thank you.
The chair calls Sarah Reyes.
Hello, not sure if I'm supposed to say good night, good evening.
Good morning.
So my name is Sarah Reyes. I'm for this bill. When I registered, I represented for myself, but it should be for Texas Criminal Justice Coalition instead, if you could change that.
Wanted to add them as yourself and Texas Criminal Justice?
If it could just be the Texas Criminal Justice Coalition.
Okay,
Yeah.
we'll fix that.
Cool, thank you. The state jail system that we know today has failed to uphold its intended purpose. The state jail has the highest recidivism rate of all correctional programs, costing the state hundreds of millions of dollars each year without improving public safety outcomes. 63% of people released from state jail are rearrested within 3 years of release, compared to that of 46% of people released from prison. Texas sends nearly 16,000 people annually to the state jail system, which again predominantly houses those convicted of nonviolent property or drug offenses, such as possession of less than a gram of a controlled substance, which is equivalent to about a sugar packet. So we're putting a felony on people who are basically having a sugar packet. In part, this high rate of reoffending may be attributed to the fact that state jails have fewer rehabilitative services available to people housing them, and that people sentenced to state jails are now eligible for parole, meaning they must serve every single day of their sentence. This reduces people's motivation to engage in services that are actually available. Eliminating the state jail felony and creating a fourth-degree felony will allow these individuals to become eligible for parole, which in turn will help reduce incarceration rate and properly transition these individuals into society. At the felony level, people experience lifelong barriers to housing and employment. Once these individuals are released from the state jail, they are dropped off into homelessness without the necessary resources one needs to transition back into the community. And the resources that are actually available to these individuals are hard to come by. People have to wait on average 2 to 6 weeks to find some type of treatment. This not only hurts the individual, but the communities in which they come from. Lowering penalties will do a few things. It will allow for these penalties to be proportional to the offense and remove the lifelong barrier that felonies create, and will save the states millions of dollars. That then can be invested in front-end rehabilitative programming. Ultimately, the state jail model needs to be eliminated. It has strayed far from the idea of rehabilitation and has become a place to cycle individuals in and out of the system. We need to stop doing harm and start taking action. This legislation offers more than reduction in prison use and cost savings. It will overall allow us to support the individuals and communities that are most affected by this.
Ms. Reyes, you came with receipts today. You have data and everything. Can you make sure you get that to the committee for us to have? Thank you so much. Members, are there any questions? Appreciate it. Thank you. Okay, the chair calls LaTanya Whittington.
Excuse me. Hello, everyone. I thank you for your time and staying this long to listen to all of us. And my name is LaTanya Whittington, and I am the executive director and founder of Cannabis Reform in Houston. And I'm here for Cannabis Reform of Houston. I'm here for myself. And I do support Representative Joe Moody's House Bill 1086, which would change penalty weights, as well as reduce penalties for possession of cannabis. Each day, I'm taking a chance to get my medicine. This doesn't solve the problem, but it could make others a lot better instead of being stuck in a bad situation. I was diagnosed with trigeminal neuralgia in 2013, which is a debilitating pain diagnosed. It's a nerve damage on the right side of my face. And so at times I can't chew, eat, talk, brush my teeth, wash my face. And I had brain surgery 2013, which they cut a hole in the back of my head and went to my seventh nerve. Please listen to me. It's the most painful thing that I've experienced in my life. It took me a year to heal, to learn how to walk. But it was cannabis that helped me. And instead of taking the 21 pills that the doctor wants to give me, some of them I do have to take. But I use cannabis to help me so that I'm not just laying in bed all the time. Cannabis healed me. And it got me up here to be able to speak to you guys today. This will be my third legislation to speak. I spoke in 2017 to help Moody. I came back in 2019, and again, it was dead on arrival. You know, that needs to stop. Texas needs to legalize cannabis. All the bills need to pass this year. In 2021, this is ridiculous. There are sick people like me who need this stuff. And I know we're talking about penalties. And that needs to happen for us too. You know, because I'm going to get my medicine. I'm going to get my cannabis. I'm going to get my concentrate or whatever that I need so that I can be productive. I have a husband and I have a daughter. She's 15 years old. And I want to be here for her. I want to be productive for her. And I say all this to say that I need all the cannabis bills passed in the House, and I needed to go to the Senate, and I needed to go to Greg Abbott's office, and he needs to sign it. Yes, he does. You know, I'm going through a depression right now. You know, I lost my mother in July from COVID-19. I just buried my twin sister Friday, Saturday from COVID-19. All of my family members are leaving me. And I say this to say that cannabis is helping me get through this. You know, I'm standing here for my mother. I'm standing here for my twin sister. You know, they both supported me with my cannabis reform. And I came here from Houston today to let y'all know that y'all need to support Moody and get this bill done for us. Because I'm not only standing here for myself, I'm standing here for others. But I needed to tell y'all my personal story. You know, there's 5,000 members on my page, Cannabis Reform in Houston. That should tell you just a little bit of how many people in Texas want this thing, you know. Listen, cannabis is saving my life. You know, I'm a grown woman. I can make my own decisions of what I want to do. This is my body. This is my choice, you know. And I'm choosing something healthy that's a plant. And people need to stop being locked up in prison for a plant. It's wrong. There's people in prison now doing years for a joint. That's less than an ounce, in which he presented Moody in 2017. Y'all know it. And I'm here to tell it. And I'm going to be up here. You'll see me again, LaTanya Whittington, in cannabis reform in Houston. I will be here for every bill until something is done. Texas is really looking crazy right now compared to the other states. This bill is just a step that we can take to help humanity, to help people. People are still being locked up, and it needs to stop. I thank you for your time and listening to me. Thank you very much.
Thank you so much for coming out to share your story, and I'm sorry about the loss of your mother and your twin sister due to COVID-19. And I'm glad that you are getting the help that you need with the medication that you're taking. I was on public health, and I know exactly what you mean about the cannabis being helpful. I've heard so many stories about that.
Yes, it helps.
And it's true. Members, are there any questions? Representative Crockett.
Just briefly, there's this misconception, as I perceive it, in this state, of if we say you're going to jail, then somehow that will stop people from doing certain things. We've now heard your very powerful testimony, and I do thank you, especially in the midst of everything that you're going through. I thank you for taking the time to, number one, be here, and then waiting, because we've been here for a long time, and you've been here.
Yes.
So I want to thank you for that. But regardless of, if this is a Class A, Class B, or whatever classification we put on this, when it comes down to you trying to make sure that you can live, does the penalty change the fact that you're willing to take that risk?
Whenever you guys decide on it, doesn't really matter. And that's for everyone. I still need my medicine, So I have to take that chance. And that's why I'm up here hoping that y'all can examine this bill, and don't let a DOA. Really think about this thing. Get involved. Talk to your other representatives and senators that you work with, and see if you can get this thing done together. Because, you guys were laughing earlier about the 3 ounces that the gentleman was taking. I started crying, because that's my life right now. I smoke an ounce in the morning. A gram in the morning, a gram in the afternoon, gram in the evening, because that's how I'm medicating myself. I have to medicate, okay? But if we can go ahead and get these dispensaries together, I can go to a doctor and get exactly what I need instead of trying to do this thing myself. That I can get the help that I need. And that's everyone. So, yes, it would make a difference, if we could get a little help with this, and this is what we're expecting you guys to do for us. You are our voices. I could just come here and speak, but you guys are our voices, and you're the one that makes the rules and lays it down for us, So that's why I'll stay to 1 o'clock if I have to, so that you can hear what I have to say. For my life, I want quality of life. And cannabis does that for me, make this a little easier on us. And again, I say, support Moody's bill, please.
Man. Thank you.
And thank you for asking me a question.
You're welcome.
Just remember, last session we passed decriminalization, so we did our part in the House.
All right.
All right.
Then y'all all right with me?
Okay. And that was thanks to Speaker Pro Tem Moody. So.
Oh, wow.
All right. Any other questions, members? Thank you so much for being here. We appreciate your time.
Thank you very much.
The chair calls Jimmy Perdue, Police Chief Jimmy Perdue.
Good evening, Madam Chair, committee. Sorry, I'm used to talking to my city council members.
No worries, Chief.
Thank you very much for allowing me to come here and talk tonight. My name is Jimmy Perdue. I'm the Chief of Police at Northwich and Hills, and I'm representing the Texas Police Chief Association. I'm here tonight to speak in opposition to HB 1086. I've been a police chief now for the last 15 years and a police officer since 1982, going into my 39th year as a police officer. And throughout my law enforcement career, I've seen many changes, both in our society and specifically within law enforcement. However, one thing that has remained consistent throughout all those years is the damage that drugs and illegal narcotics have done to the residents of our state. As you know, HB 1086 is a multifaceted bill that asks for several different changes in many different laws. I won't try to speak on each and every one of those, but rather focus my comments on two specific issues. The first involves the request to change the name of the state jail felony to a fourth-degree felony. If this were a simple cut and replace, there'd likely be no opposition to this name change. However, there are several structural changes that the bill is proposing that is linked to the name change, making these unsupportable. The major objection to this bill concerns the changes that are requested in the classification levels for several drug possession offenses. The bill seeks to lower the possession of Schedule I drugs, that's cocaine, heroin, methamphetamine, of less than 1 gram from a felony classification to a misdemeanor. It proposes that for some drugs of less than 20 doses, like LSD, as well as a drug such as amphetamine and ecstasy, making each a misdemeanor. Equally concerning is a recommended change for up to 5 pounds of marijuana be lowered from a felony to a Class A misdemeanor, and a decrease in the classification for marijuana possession under 4 ounces from a Class A to a Class B misdemeanor. This change quietly attempts to raise the beginning threshold for marijuana possession from 2 ounces to 4 ounces, a fact that has not been discussed except by one of the advocates. There are several other changes, all equally objectionable to these, that I've already enumerated. In addition to my regular job, I also am a member of the International Association of Chiefs of Police for over 20 years, while serving on the Narcotics and Dangerous Drug Committee for the past 10. In this position, I've had the opportunity to see the damage that drugs have done all across our country. Many other states have tried things similar to what HB 1086 proposes, and these are often the first salvo in an attempt to further decriminalize our illegal drug use, or at least desensitize the public to the damages done by the illegal drugs. The damage these changes have made in these states are now becoming clear, with increased overdoses, hospitalizations, intoxicated driver, and overall cost to their societies. In my almost 40 years in law enforcement, I have observed that Texas has always believed in having a strong legal deterrent philosophy in place to hinder the possession and use of illegal drugs and narcotics. Even with this philosophy in place, several changes in these laws, some positive, have been made in recent legislative session with a long-term effects yet to be seen. The Texas Police Chiefs Association stands in opposition to any attempt to further decriminalize or to reduce the classifications which may further the legalization of drug usage and are in opposition to HB 1086. Glad to answer any questions, Mr. Chairman. Chairwoman, excuse me.
That's okay. That's fine.
Sorry.
Representative Crockett?
Thank you so much for waiting it out.
Certainly.
It's going to be tomorrow in a second. So one of my first questions is, it seems like you have a very rich criminal justice history, and you talk specifically about the drug possessions less than 1 gram of the meth, the penalty group 1, right?
Yes, ma'am.
And so you would agree with me that the majority of the time we classify someone who maybe is being charged with this type of possession as a user and not someone who's a seller or a deliverer. They're usually a user, correct?
Those that are in possession of less than 1 gram are typically a user?
Yes.
Yes, ma'am.
Okay. So you would agree with me that we're talking about someone who potentially has an addiction when we're talking about those low-level, less than 1 gram type of offenses. We're not talking about someone who's out here selling, grams upon grams. We're talking about someone who potentially has an addiction. Isn't that right?
Typically, yes, ma'am.
Okay. In addition to that, you mentioned the marijuana, and we've heard testimony, I guess, now from 3 different people as it relates to marijuana. And while I can appreciate your track record and your history, the reality is that we know that number one, Texas will not fall apart if we truly, and this bill doesn't do it, but if we fully legalize marijuana, because we have the evidence from various states that have legalized marijuana in some way or another, and there's nothing that shows that there's some great increase in crime or anything like that, right?
No, ma'am, that's not true.
Okay, so you disagree and you believe that there's a great increase.
I believe that there is, as I said, there's an increase in overdose, there's an increase in hospitalizations.
I'm talking about the marijuana specifically.
Take your choice of the legalization of marijuana. In every state that is legalized, there has been an increase in hospitalizations, in overdose, in intoxicated drivers, and the cost of society, as well as crime.
Okay, so let me talk to you about this. There was an unintended consequence, which I consistently speak about unintended consequences in this room for sure. There was an unintended consequence last session when technically we did not legalize marijuana, but there was an inability to actually prosecute those marijuana cases because we brought up the legalization of hemp. And so then there was a difference. When you look at hemp and when you look at marijuana, it's the same plant. The only difference between them by legal definition is the amount of THC or the percentage of THC that exists within it. And at the time, we didn't have the testing available. In fact, most prosecutors at this point still are not prosecuting those cases, and any halfway decent defense attorney is actually pushing them to trial because the state can't prove those cases for the most part, because now it's not so much as an officer can just testify as an expert and say, hey, this is marijuana. Now we have to rely on the science to prove that it is. And even though we're in that circumstance because of the unintended consequence, are you here to give us testimony that something has dramatically changed in the state between last session and this session, even though to some extent we kind of legalized it accidentally? Kind of.
I would disagree with your characterization that we have somehow legalized marijuana by the hemp thing that has occurred, because in many counties, one my own county, we are still prosecuting, the district attorney is still prosecuting marijuana cases, certainly with a lab test that goes on. My district attorney has not said there will be no prosecutions, that that's still occurring. I can't sit here and tell you that within the less than 2 years since that was done, that there has been a dramatic change in the state of Texas. I don't believe that what has occurred last session would have caused the very thing, because the states that I'm talking about where they've done legalization of both either marijuana or wholesale narcotics, like they've done in Washington and Oregon State and other states across the country, it's much more dramatic and much more significant to the society.
Thank you.
Yes, ma'am.
Members, any other questions for Chief Perdue? Thank you so much for being here.
Yes, ma'am. Thank you.
The chair calls Elmer Beckworth. I hope I spelled it correctly. I'm so sorry. I said it.
Good evening. We haven't already passed to good morning. I'm Elmer Beckworth. I'm district attorney in Cherokee County. I'm a district attorney, so I'm a felony prosecutor. I will be able to cut my testimony very short. I, as it is appropriate, went by Speaker Pro Tem Moody's office today, spoke through the door to his staff. We were not able to meet. He has graciously agreed to meet with me, so I'm just going to announce I'm opposed to the bill. But some of the things I'd like to visit with him about, and I agree with him, when the state jail felony was set up, there was supposed to be a whole lot of programs, both in terms of community supervision and at state jail, that the nothing personal to your predecessors, but they were never funded. And what I want to visit with him about, and what I think is a key issue that I'm concerned about the bill, is so there is probation for a long enough period of time to do the rehabilitative programs, especially for methamphetamine, heroin, and cocaine, and particularly where there's no reduced use of SafeP. SafeP is the most successful drug program we have, and one reason we try to utilize it as much as we can. When someone successfully completes SafeP and doesn't relapse, we don't see them in the system again. So I would like to meet with Representative Moody. I appreciate his overture, and I still subject myself to any questions.
Thank you so much, DA Beckworth, for taking the time to be here and to stay all this time. I would agree. I had a chance to visit a SafeP and met some remarkable individuals who were about to complete the program. And they said it was tough, but the best thing that has happened in their life. Their prospects, their future looked very bright. So I would agree with you about the SafeP program that I visited, the place I visited. Members, are there any questions for the DA? Representative Johnson.
Thank you. Just to go back on this history a little bit, when we passed, or when the legislature passed state jail felony, just like you said, and said everybody needs to do probation, we want to deal with addiction, and then it got screwed up because it never got funded, right?
There were supposed to be a number of programs at state jails themselves. That's what didn't get funded.
But we also had the requirement that if you were an automatic less than a gram, you were going to get put on deferred adjudication. You were going to be required that you were going to have an option to not get a conviction. And then we have not followed through with that concept.
If my memory is correct, I think it was mandatory probation. Of course, first offense, almost all of us use deferred adjudication anyway.
And the point was to try to get people who were addicted to not be convicted of a felony.
Correct. For the ones that didn't have multiple cases pending, there wasn't any evidence that they were dealing and only got caught with less than a gram. But for the people who was less than a gram and addicted, try to get rehabilitation. And
we have failed in that. And we, like 1244A, which maybe you experience in your jurisdiction, we've convicted a lot of people of felony convictions that we had better intentions for, right?
Right, except I agree with 1244A for this reason. The programs and SafeP beds, unfortunately, are limited. One thing that would solve a lot of this, and I know this is the wrong session during COVID to ask for it, but there'd be more programs and more success with rehabilitation and probation if we had more funding for more programs. And though, like I said, it's a bad time, that bill's not before you. But
let me ask you this. When they get out of SafeP, they're convicted felon, right?
Not if they get deferred.
But if you get deferred and you go through SafeP, fine. And then you get a termination, and then you get a petition for non-disclosure, right? My experience hasn't been so rosy with SafeP. And so for those... Really? And so for those that violate and get convicted, you have a lot of personal use addicts who are now convicted felons. Right?
Usually for the ones that get SafeP on probation, there's a lot of jurisdictions, it's last resort stuff. Ours, because of lack of programs, sometimes it's used more often. Plus, it used to be about above 50% success rate. When the amount of time in SafeP was reduced, I think it's around 50%. But usually it's not pure personal use. Sometimes there's other crimes involved, usually burglary, stuff like that.
Let's back it up. If I'm charged with less than a gram and I get convicted, more than likely it was personal use, right? We just heard the chief when Representative Crockett asked the same question, that from that police officer agreed that less than a gram is usually personal use.
Correct.
There's not intent to deliver, because if there was intent to deliver, we wouldn't be charging them with a state jail felony, right?
Possession with intent to deliver is a state jail, if it's less than a gram.
Okay. If they get convicted, they're a convicted felon.
If on a first offense, they're offered,
Thank you, Madam Chairwoman.
Usually there's, for someone to get straight probation on state jail, they usually have some long misdemeanor history or something else. Usually deferred happens as a first offense.
Okay. I'm trying to find the SafeP that I went to because it literally was out of, the people there were wonderful. So I'm interested to learn more about the one you went to. Mr. Beckworth, DA Beckworth, who are you representing? Are you here?
Myself and I guess my office.
Okay, the district attorney for Cherokee County.
Yes, ma'am.
Okay. Members, are there any questions, further questions for the DA? Thank you so much, sir.
Thank you.
The chair calls Lauren Johnson. She's a virtual witness. Hi, Ms. Johnson. You're on live at the committee. Would you please state your name, who you represent, and your position on House Bill 1086? Can you unmute yourself?
Yes, I am watching the live stream, so let me quiet that really quick because apparently it's delayed. Hi, my name is Lauren Johnson. I am here to testify in support of the bill with the ACLU of Texas. And thank you so much for your very long evening tonight. The committee recently received a report that the Smart on Crime Coalition released, and the bill follows some of the recommendations of our coalition. If you haven't had the chance, I would encourage you to read the report, but what I want to say is that Texas can do better. So we can more right-size our approach to low-level crimes. This bill brings us an opportunity. We've had years of stakeholder meetings and attempts to reform the state jail system, and this bill gets us closer to that. And brings those ideas and solutions to fruition. What we know for sure is what we're doing right now is not working. And the state jail system has the highest rate of failure as marked by the rate of recidivism, as well as the amount of money that we are paying for the poor rate of return, not to mention the human impact. So I'm not going to launch into the background on the state jail system because I think the committee is well aware of that, but personally, I have been in the state jail system twice, and I can tell you that those times that I spent in the state jail system were not rehabilitative. I also did Safe P one time. My last incarceration was after Safe P, and it was for trace amounts of a controlled substance, for methamphetamine. It was a relapse, and I wound up doing 7 months that I did not get access to rehabilitative programming. I did not receive educational components. Like, what I needed was an opportunity to have treatment components in the community under supervision where I could also care for my family, and those were not options for me because I had been to prison before, which is a very common thing for people that have substance use issues. And so you know, TDCJ does have a lot of programs available. The problem is most of the people that go into the state jail system don't have enough time there to qualify for them. And those people would be better served and more cost effectively served in the communities. Recovery is a process, is what I'll say. And so, you know, the first time that you go into treatment, you may not come out and be ready to be done with drugs, but all of the things that you learn in that treatment process don't go away. You don't lose that information. And when you are ready, you're able to access that information and get on the right track. And so what I would say is that earlier, you heard the quote about the definition of insanity being doing the same thing and expecting a different result. And that's relevant because that's the motto in community recoveries, or recovery communities, sorry. But it's also appropriate to the way that we continue to do more of the same thing with the expectation that people will transform their lives in a system that is designed to not help them do that. And the collateral consequences of a felony don't go away. They are forever. So I know earlier that the police chief mentioned the devastating effects of drugs on our communities, and I know firsthand that that's true. But what I also know is that punishing those crimes the way that we currently do is insanity, and it's not effective and it's not working. So I can tell you that when I used substances and I understood that I needed help, it wasn't available. There was a 6 to 8 week wait to get into treatment services. That's where we need to be focusing our attention, because punishing this stuff, I can tell you as a person that has used substances, the punishment hanging over my head was never a deterrent. The deterrent idea doesn't work in this case. So what we need is to offer supports to people when they're ready, that are accessible at the time that they're ready. And the other thing that I'll say is that we know that communities of color are more heavily represented in the populations that are policed and incarcerated for these crimes, but they're underrepresented in being able to access treatment both on the front end of the system and through probation and parole.
Well,
and so I'm happy to answer any questions.
Yeah.
The last thing that I would mention, though, is that currently, prior to COVID, we had a court backlog that was not great, but since COVID has hit, those backlogs without an intentional intervention are going to be impossible to dig our way out of. And so by changing the penalty ranges and addressing the needs of people, like the direct root causes of the crimes that they're committing in the community, switching those down to Class A misdemeanors and the other punishment schemes that are listed in HB 1086 would reduce the backlogs in the district courts, and it would move some of that into the municipal courts where people would spend less time in county jails. And so it would be better for the entire system. I'm happy to answer any questions, but I know it's late and you guys have been at this for a while.
Thank you. Members, any questions? Thank you so much for your testimony.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 1086? Seeing none, the chair recognizes Speaker Pro Tem Moody to close.
Thank you all for your time and attention. Back to the enhancement provisions, section 45 and 46. And they went back and forth on this. So I apologize for not noting this earlier. It's going to be treated like we treat state jails now. So we essentially just scratch out and put fourth-degree felony in there. So however we were doing that for enhancements, we're not going to disrupt that for habitualization purposes. I want to thank everybody for coming. I specifically want to thank the Chief of Police and the District Attorney for having the courtesy to actually come up here and testify, because there are other people who decided to sign a card and they're against it. It's look very impressive that they're against it, but didn't have the courtesy to come up here and talk. And so I always have more respect for folks that have the courtesy to come up here and talk to people and discuss why they have differences of opinion. It's important. This is an exchange of ideas. With that being said, I do think it's hard for me to understand how someone can testify that our current drug policy is working, or that our state jail policy is working. And I say this while I know that Alan Place is sitting back there, and Alan Place sat in our chairs before. And he was guided by a philosophy that he wanted a fairer, better criminal justice system, and helped create this system. Not because he thought it was going to saddle people with felony convictions that didn't get meaningful help in the system, but because he thought that later generations that took the seats behind him would fund those programs and get the things done. And that didn't get done. And we've had multiple conversations about this. I do not mean disrespect to those who tried to put a good system in place. It just isn't working the way it was supposed to. The numbers just don't lie. State jails aren't just a warehouse for people struggling with addiction and poverty. They are a factory for more addiction and poverty. They're doing the opposite of their intended purpose. So let me tell you a little secret about the war on drugs. We lost. All of us. And that's because we're dealing with addiction problems in the criminal justice system instead of the health system. For locking people up we're mad at, essentially, and for what? It doesn't get them to stop using drugs because addiction doesn't work that way, as you just heard Lauren Johnson talk to you about. If we truly want to stop that behavior, we need to get them services, and that doesn't happen currently the way we use our state jails. We spend hundreds of millions of dollars every year on state jail enforcement and get nothing for those dollars. People come out worse, not better, because now they're convicted felons, to Representative Johnson's point. They're going to have a harder time getting a job, getting occupational license, getting stable housing, getting an education, and so on. If a financial manager kept making the same bad investment that never paid off whatsoever, it wouldn't take nearly 30 years to fire that person. But that's where we are today with the people's money. We have to do a better job. I'm not surprised that there's opposition to this bill or where it's coming from. No one wants to have their options curtailed. Everyone in every system wants more power and more leeway to do as they please. But it's our job as legislators to create laws that strike a balance and achieve good results for the people of this state. The state jail system doesn't do that. It never has. And under its current construct, it never will. So I would ask you to allow us to take a different course. With that, I'm happy to answer any further questions. If not, I close.
Members, are there any further questions? If there's no objection, House Bill 1086 will be left pending at this time. Thank you so much.
Thank you, Madam Chair. May I be excused?
Yes, you sir. Yes, sir.
Thank you, Tim.